Federal Flaws, Perceiving the Problem. Segment 3, Federalism. Federalism is the concept of establishing a shared responsibility of government power between different governments. In the American system of government, federalism refers to the separation of powers between the states and the federal government. The states are generally responsible for local matters, and the federal government in Washington, D.C. is responsible for major international matters. Alexander Hamilton was a leading member of the Federalists. The Federalists were advocates of a strong central government. They felt that the states should be junior partners to the central government. When the Constitution for the United States of America was first proposed, Hamilton, along with John Jay and James Madison, wrote a series of essays called the Federalist Papers to urge the public to adopt the Constitution. Hamilton's version of what the federal government should be looked more like a national government than a federal government. The idea of a strong central government was not popular so soon after a war revolution against a powerful central government in faraway London. So the Federalists had resorted to a sneaky piece of legalese when constructing the Constitution. Article 1, Section 8 of the Constitution for the United States of America defines the powers of Congress. Those powers include things like the ability to lay certain taxes and the power to declare war. The last power on the list is the power to make the laws necessary and proper for carrying into execution the powers listed in Article 1, Section 8. At first glance, this sounds like an enabling clause that just said Congress could pass laws on things like taxes and war. This is not what it says. What it actually says is necessary and proper for carrying into execution the foregoing powers. This means that the powers of Congress listed in Article 1, Section 8 were not the process of Congress's power. They were the goals, or to be more precise, the ends. Almost anything Congress wanted to do to achieve those ends was considered acceptable, because the power to determine what was necessary was given to Congress. The idea can be roughly translated as the means are justified by the ends. Under the original Constitution, if Congress wanted to suspend jury trials to help win a war, that was allowed. Hardly something we would consider acceptable today, but this was before the Bill of Rights was ratified. The states ratified the Constitution for the United States of America with a promise of a Bill of Rights to come. The first 10 amendments put in place protections for things like free speech, religion, and the right to bear arms for the people. The 10th Amendment also gave some protection to the states as well. In 1819, the Supreme Court handed down the decision in McCulloch v. Maryland that supported the original intent of the Necessary and Proper Clause. The controversy in McCulloch v. Maryland was that the United States had created the Second Bank of the United States and opened a branch in Baltimore, Maryland. Maryland didn't like the idea of the federal government opening a bank in Baltimore without the permission of the state legislature, so Maryland laid a tax on the bank. The bank refused to pay the tax and sued the state of Maryland. The Supreme Court found that the bank was a legitimate means to accomplish the taxing and spending powers of the federal government, and that a state could not interfere with the bank or tax it because of the Necessary and Proper Clause. From the decision in McCulloch v. Maryland, let the end be legitimate. Let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited but consistent with the letter and spirit of the Constitution, are constitutional. To paraphrase, the ends justify the means. In 1824, New York and New Jersey were arguing over who should be allowed to license ships on the Hudson River, which was shared by both states. New York had granted monopoly rights to 2 shipping companies. New Jersey made it illegal for anyone with a New York license to travel in New Jersey waters. The United States responded by issuing its own license for water traffic. The Supreme Court ruled that the Commerce Clause gave the United States the right to regulate navigation, and the Supremacy Clause meant that the United States license for shipping had to be accepted by both states. The Commerce Clause is found in Article 1, Section 8, and gives the Congress the power to regulate commerce among the states. This is generally referred to as interstate commerce. The Supremacy Clause is found in Article 6 of the Constitution and states that when Congress has the authority to pass a law, that law will supersede laws passed by the states. In Gibbons v. Ogden, the Supreme Court stated that the states and the United States would share lawmaking power in some areas. The states could pass laws as they saw fit unless the United States exercised its lawmaking power. The court went on to determine that the power of the Commerce Clause was so broad that the wisdom and discretion of Congress, their identity with the people, and the influence which their constituents possess at elections are in this, as in many other instances, as that, for example, of declaring war, the sole restraint on which they have relied to secure them from its abuse. In other words, the courts would not even recognize the Bill of Rights as protecting the people from the reach of the Commerce Clause. We never say that freedom of speech would take a back seat to the Commerce Clause today. How could the court come to this type of decision? Wouldn't the court recognize the powers reserved to the states under the 10th Amendment? The Federalists were instrumental in writing the Constitution, but after George Washington and John Adams, the Federalist Party ceased to have popular support. Right before John Adams left office as the second president under the Constitution, he packed the courts with Federalist judges. The most famous among them was Supreme Court Chief Justice John Marshall. The Marshall Court continued to support the cause of a strong central government long after the Federalists lost political power. The story of how the Federalists lost popular support is the key to understanding how federalism developed. Under President John Adams, the Congress passed the Alien and Sedition Acts. These were 4 separate laws that made it illegal to criticize the federal government and gave the president the power to deport foreigners. The laws were a response to French agitators who wanted America to join with France's war against England. This was a policy the Federalists opposed. The Alien and Sedition Acts were a clear abridgment of free speech, but it was to the benefit of the Federalists who were in power at the time. Kentucky and Virginia passed resolutions saying that they would not allow the Alien and Sedition Acts to be enforced in their states. It was a nullification of federal law. Most of the debate about the resolution centered around a different concept of federalism put forward by Thomas Jefferson. Hamilton's federalism had the federal government in charge, with the states being very junior partners. Jefferson's federalism saw the government as near equals, with different spheres of influence. Jefferson also viewed the Constitution as a contract between the states and the federal government. Jefferson felt that the states had the right to interpret the Constitution as a contract on equal footing with the federal government, and that power to interpret the Constitution gave the power to nullify unjust laws like the Alien and Sedition Acts. Jefferson's reasoning behind this had to do with the difference between positive law and natural law. Positive law is the law of civil societies. Positive law is made by the proper authorities and positively written down in a public way. It doesn't matter if it's Congress, a king, or a dictator that makes the law, it must be followed. Natural law is law that is self-evident to achieve justice. It doesn't necessarily need to be written down, even though we generally require it in the United States of America as part of due process. Theft and murder are crimes that every sentient being should recognize as being wrong. War crimes are usually prosecuted under some aspect of natural law. Natural law is a prerequisite for government by consent. The Declaration of Independence establishes that all governments derive their just powers from the consent of the governed, not from the consent of a king, of a dictator, or even the majority of voters. Democracy, or rule by the majority, is on average the mildest form of tyranny, which is why our federal and state governments are constitutional republics, not democracies. The ability to reject laws which cause no harm to a victim, but are only intended to oppress one group of people for the exploitation by another group, is the fundamental tenet of natural law that justified the American Revolution. Without this element of natural law, the Founding Fathers would have only been terrorists who won a war. The principles of natural law that were adopted into the positive law of the United States of America by the Declaration of Independence were at odds with the broad grant of powers of the Necessary and Proper Clause of the Constitution. Hamiltonian federalism had been the original intent of the Constitution, but if the federal government ever exercised those powers, a violent revolution would have been the lawful result. Hamilton's federalism was defeated by the Bill of Rights, but it was not Jeffersonian federalism that was adopted. The problem with Jeffersonian federalism is that treaty law is positive law, not natural law. The natural law tradition of England viewed the law as a social contract between the free people and the king's government. This wasn't exactly true, but the concepts of contracts could be imagined in this way. As a contract between two parties, each side could be allowed to argue the meaning of the contract. Under the natural law system, a person could try the facts of the case and what the law meant to an individual defendant with a jury trial. This is called jury nullification, and it still exists in courts of law today. Under a federal system, there weren't two parties to the contract anymore. There were three: the people, the states, and the federal government. A natural law contract is an agreement. The paper we call the contract is just evidence of a contract, not the contract itself. Under natural law, the parties to an agreement can contest the original intent of an agreement. If the legislature was allowed to change the meaning of a treaty by changing the members of the legislature, treaties would have no meaning at all. The Constitution for the United States of America, which is a treaty, would have no meaning. Jefferson's idea of nullifying a treaty based on natural law has no place in a federal system. Treaty law is positive law, not natural law.